statement.
Thanks, Chairman Langford, and thank you all for coming in. It's the hardworking redheaded committee, I want you to know. This is I'm sorry, Joni. Sorry, Joni.
Joni's an honorary member today.
She is. Yeah. She is. Of course, we don't know what color her hair used to be, but I think we're going to call you redhead. Thanks so much for coming in, and this is a touchy subject because when you look at guidance, on one hand, it can be critically important to helping agencies kind of clarify their position, giving greater direction and knowledge to those who are regulated. But on the other hand, it can be used as a shortcut, and we've seen it used both ways. And one of the great challenges that we have is trying to figure out how we're going to balance those two things. And as Chairman Langford said, what are we going to do to actually get to the point where we feel comfortable here that guidance is not used as a shortcut to reinvent or to restate current regulation in a way that is inconsistent with either the law or inconsistent with past regulation. And so I'm going to just submit my opening statement for the record and welcome you all, but tell you that that really is the challenge that we have on this committee, is trying to figure out, because we've seen it both ways, trying to figure out how we do what we're supposed to do, which is provide oversight over agencies, but also give both the regulators and the regulated the option to have clarification that can be enormously useful, especially in the business world. Mr. Ahmed, I'd like you to engage. Obviously, nothing is going to happen here unless we do have steps that we can all take together. At some point, the paths may diverge, but I think there are some steps that we can all take together. And I think that when you look at, kind of through the lens of we're in charge now, so we're happy, but tomorrow we might not be in charge and we might not be as happy. So these rules should set a framework or a foundation in which to evaluate rules no matter which side of the political spectrum is promulgating those rules. And so I'm curious about, this path that we're talking about, taking these steps, whether this is something you guys have thought about, and, is this a process that you think folks who tend to be very concerned about limiting regulation could see some benefit to?
Sure. Here are our concerns. So I don't see a problem with agencies of their own volition, under their own discretion, like the FDA, instituting different processes for certain types of guidance documents, significant guidance documents, and my understanding is that the FDA still continues to do that. It's a process that's worked well for them. At the same time, I don't agree that a one-size-fits-all approach that basically turns the FDA process for significant guidance documents into the process for significant guidance documents at all agencies is the right way to go. One-size-fits-all approaches normally result in unintended consequences, both for guidance documents that we believe are important in protecting the public, like the recent CDC guidance, but also guidance documents that are important in addressing areas of regulatory uncertainty quickly. And that's exactly what no-action letters do. The other concern I have is that guidance documents are distinct from rules. The distinction is based on guidance documents not being binding. Now, if you were supposed to, if Congress was to essentially create a process that resembled notice and comment rulemaking for guidance documents, but kept those guidance documents non-binding, seems to me that agencies then really have no incentive to go to issue guidance documents since they have to go through basically the same process as notice and comment rules, but with guidance documents they're non-binding, and with rules they are binding.
Except many times, not many times, but we've seen significant changes. Let's say these are the rules, and all of a sudden in a guidance document, those rules don't apply anymore. So it seems to say to me that something changed, and that if you're simply interpreting a rule or a statute that gives clarity, but when you simply, when you turn the boat and say, now we're going to go in this direction, like OSHA did with some of the anhydrous rules, then we get a little suspicious, and we say, wait a minute, for the last, decades, this was perfectly acceptable in legal behavior. We had been communicating with OSHA. We'd been complying with the rules. Now they're telling me we can't, we can't do this, and in fact, we could be out of business. Don't you think in that case you would argue that a guidance, albeit not binding, but certainly terrifying, in the case of the regulated entity, that there should be more notice and comment. There should be more availability in terms of oversight, rather than doing it through a guidance. And so I think, I don't want to think that this is like the big issue in terms of regulatory reform, but I do believe that guidance is used as a shortcut, and that shortcut denies the ability of the agency to get enough input to maybe choose a path that could in fact be a better path and provide more safety, provide better outcomes for both the regulated and the regulator, and the consumers. So I think we're at this kind of impasse here where, where I'm trying to find which steps we can take that could achieve some kind of consensus to actually open the dialogue. So I'm going to ask you, what about transparency? I mean, I think that's a fairly, bipartisan notion that no matter what an agency does, we have government in the sunshine in our states, and we have freedom of information here. Isn't transparency pretty critical? That if you issue a guidance or a letter to my competitor, and I don't know about it, and I'm still operating under another set of rules or another set of what I think the rule says, isn't it important that we have transparency? And couldn't you agree with these two that a transparency step might be a good way to do oversight on our side, but also level the playing field for the regulated industries?
I agree that transparency is essential, generally speaking, to the regulatory system. And I think there is actually a great deal of transparency when it comes to guidance documents, at least the existence of them, the issuance of them. I think there's more transparency than they're given credit for from some sources. Now, at the same time, so I'll give you an example. No action letters, they are put on the website, even though they're directed to specific parties. They're put on the website by agencies to make sure that other parties' competitors, but also the types of businesses that do the same activities as the ones receiving the no action letters also know that their activities are not going to result in enforcement actions against them. Transparency, I think there could be ways to work with, on a bipartisan fashion, work with folks that are interested in transparency reforms for guidance documents. The devil is always in the details, and generally speaking, I think the preferred way to go, in my mind, would be for Congress to push agencies to adopt, on an individual basis, when they feel it's appropriate, transparency guidelines for issuance of guidance documents that impact the public. One-size-fits-all approaches, congressional legislation, can result in unintended consequences, certainly can result in additional delay in the regulatory system.
Mr. Noe, I have a question for you, because this is a theme that I have sounded many times from this desk here, is that Congress does big things like Dodd-Frank, they do big things like the Affordable Care Act, and they get bogged down and they can't give, a lot of direction because it's harder to do big things when you get into the details, and they just throw this stuff to the agencies and say, good luck. And then we all, pound the table when they do something that results in complaints from constituents and is contrary to maybe our philosophy. How do we kind of achieve a recapture of that responsibility for legislating in a world where we're doing big things that are so complicated?
That's a great question, Senator, and I think part of it is Congress helping to channel agency discretion in a way that's going to be reasonable. We could have a whole separate conversation about regulations on that, but since we're talking about guidance today, there are just very fundamentally basic principles that are good government principles, and this is not I think, a occasion for partisanship, which is there ought to be basic approval procedures for guidance in the agencies. That's not happening now. Our government shouldn't be the worst form except for all the others. We ought to have a government that is something we brag about. And the idea that there are not basic approval procedures in the agencies being followed now, there are not basic compliance with these simple good guidance practices that are laid out in basically a page, that there are not public access to all the guidance right now in cabinet level departments that should be the envy of the world. There's not public access to these documents. The GAO report that was done documents this in detail, but they found HHS, and of all departments, that ought to be one of our very best, that they did not consistently apply good guidance practices. Their website did not link to the guidance documents. And GAO, with their experts, were not able to even find them on the website. I mean, that is no way to run a railroad station, and we're not meeting these basic principles for what is competent government, what is transparent government. And in terms of public feedback procedures, well, just like OIRA staff can't be expected to be responsible for something they never heard about, how can the public possibly be held to account for guidance documents that GAO can't even find on the agency's website? But that's the state of where we are today. So what's happened is it's been over 9.5 years since these basic practices were issued by OMB, in a Republican administration, reaffirmed by a Democratic administration, and there's gross noncompliance. I mean, I think it's embarrassing. And I think it is time for Congress to step in, because no rulemaking of any kind, whether it's regulations or guidance, happens without the delegation of this authority from Congress. It's time for Congress to step in and say, we're going to have basic rules of the road for agency guidance. And we're going to do what's been bipartisan, has broad support in the academic community, and we're going to elevate that into law because the agencies are flaunting it. I can give you some statistics. Amit talked about empirical evidence. I can tell you the numbers on how gross the non-compliance has been with the bulletin, okay? In the entire 9.5 years since it's been issued, the agencies have said there are about 3 economically significant guidance that merit pre-adoption notice and comment. 3, okay? In terms of the significant guidance, and those aren't even expected to have pre-adoption notice and comment. Those are just that you have approval process for this. You list basic elements. You say you're not binding in the guidance. Of those, okay, here's what GAO found in a study. The Department of Agriculture has issued a grand total of 34 in 9.5 years. That's about 4 a year. Department of Labor, about 4 a year. Education, about 4 a year. I can assure you those agencies issue hundreds of guidance a year. There's this House look into this that is a number of years ago, but basically they looked at several major agencies and found that in a 3-year period they had done thousands of guidance, okay? So the notion that when you're talking about that level of guidance, 4 of them even merit the standard basic good guidance procedures being followed, and 3, a grand total of 3, they acknowledge merit pre-adoption notice and comment. That's embarrassing. And I think it's time for Congress to step in and do something about that. And this committee is the perfect venue for that. That's what's in your mission, is to improve the rulemaking process.
Senator, can I add something quickly?
Yeah.
So good government requires resources. And what we're seeing currently is that agency budgets, basically outside of the national security agencies and TSA in particular, agency budgets have stagnated or declined even. I'll give you another example, OIRA itself. OIRA staffing has stagnated, declined to a certain degree. If we're going to impose mandates on both the agencies in terms of additional procedural steps for guidance documents and at OIRA in terms of review, and I have to say the recent track record of OIRA regulatory review is not very good when it comes to delay. We've had unprecedented delays under this administration. They've gotten a little bit better under Administrator Shalansky, but we've had unprecedented delays. We're going to need to, Congress will need to provide the resources to make sure that we have good government. You only get the government that you pay for, and so good government really requires good resources.
Subsignificant.
I think one of the issues that we have is that, probably a unfair kind of analogy, but let's say you have 5 sisters and you all have photo albums and one just throws them in a box and the other person, has them indexed, 500 different ways on a spreadsheet, right? So we haven't set any guidelines for how this information is presented. Now we've got a whole body of work out there that's in the shoebox. That is not necessarily accessible. And so it's going to take, maybe some direct analysis on this is the expectation on transparency. This is, you shouldn't have to, dig around. You shouldn't have to just wonder if you're missing something. There should be one place where you can go, where you can sort it. And the problem that you have is I think this has been ignored, kind of like, we're just doing it because people are busy and they aren't thinking about communication. They're just thinking about today, not what this body of work means kind of in the long run. And so I think there is some work that needs to be done in terms of not just one size fits all, but in terms of setting some standards for how you present the material. Our frustration here has been every time we talk about whether it's taxpayer bill of rights, whatever it is, post this information. Well, that would just take so much time. Well, I think, number one, we have the tools to do this fairly quickly, but people don't have a framework. And when they say, well, we can't post it, you wonder why they don't want to post it. Not that everybody can post it. And so I think there's a need here to maybe set some standards on how the information is presented. We can argue about what's significant and what isn't, but all of this information should be completely transparent and accessible to the public.
A quick one on that. I love the shoebox analogy, and I'll tell you the shoebox is called notices at the Federal Register. If you look at the proposed rules coming out every year, right now there are 2,500 in the pipeline. The number of rules finalized last year were 3,410, but the notices were 23,000. And say, just notices is what it's called, but it contains memoranda, note directives and guidances, bulletins, letters, all a word salad of things that it includes, and it's just in that shoebox now. One of the things you can start to do is to tease that out, because some things like the FDA notices that Amit mentioned that are just alerting the public about things about Zika, those aren't guidances that concern anybody. Those are notices coming out of the federal government. But the ones where it's going to change behavior or require businesses to react, or some businesses may act differently than others, or be affected differently by others, I think those can be pulled out of the notices shoebox in the Federal Register reporting that comes out every year. So I think that kind of disclosure and presenting the significant guidance and the material sub-significant guidance straight on the webpage, along with elevating the guidance principles like Paul says, I think will go a long way toward getting a handle on this issue.
One of the problems that we have when we look at this is a lot of the significant guidance, a lot of the significant regulations are coming out of independent agencies, and we're really challenged in how we do that independent agency review. We had a bill, it's been really, really a tough issue for us to kind of navigate in terms of our oversight. But I want to make a point about guidance because I used to be one of those regulators back in the day, both as Attorney General and as Tax Commissioner, and I got criticized for not promulgating rules and not issuing guidance because of how critical it was for business certainty. You may not like the answer, but you got an answer, so you can rely on it. Again, I don't know that we can say safe harbor, but certainly during the term that we would have a court would say, look, you said something, they relied on it, it's binding. And so we don't want to lose that. And Mr. Narang, I think that one of the things that we need to look at is we need to think in the context of if the person in the White House didn't share common values, and started issuing guidances that were contrary to rules that had been promulgated over the last 8 years. How would we then want to see the process operate so that we would at least have noticed that there's some erosion from what you thought the principles were or what the rules were? And how could we, I think sometimes we look at this in the lens of what the political landscape is today, and we desperately need to look at it from, what's the level playing field that we need to be operating on. So regardless of the political affiliations or the tendencies on either side, we have rules that we all know. I mean, couldn't you see a need in a case like that to actually have greater notice, have greater scrutiny over guidance that might change rules?
I think that you're absolutely right to point out that the procedural issues when it comes to the regulatory process can cut both ways depending on who's in the White House. I don't think that diminishes the need for our government to operate efficiently. I agree that they should operate in a transparent manner, regardless of who is running the show. But I do think, and certainly that may cut against public citizens' interests sometimes, but I do think that government efficiency as a principle is also a bipartisan principle that needs to be honored across administrations. And we don't have that with the rulemaking process. We are very concerned that adding the same types of procedures for guidance documents will simply make the dysfunction and inefficiencies in the rulemaking process then apply to guidance documents.
Well, I have a concern if guidance truly is non-binding, whether we're putting another layer on that would prevent us from moving efficiently to give business certainty to do the kinds of one-on-ones that can be very, very helpful. But I have seen it go the other way too, where broad sweeping changes are done in guidance when they should have been done in rules.
If I could just add to the OIRA discussion really quickly. We talk a lot about transparency around here. One of the major sources of a lack of transparency when it comes to the regulatory process is OIRA. The GAO has issued multiple reports now, making about 12 recommendations when it comes to OIRA actually following the Executive Order 12866 transparency requirements. Every time the GAO finds that OIRA really isn't interested in instituting their recommendations, I think they've only done about 1 out of 12. We really feel that if we're going to give OIRA more authority over more types of agency actions, that they need to right the ship when it comes to reviewing regulations first before we give them guidance document review authority.
So can
I think one of the concerns are the nitpicking versus truly significant breaches of process. And I think that people on the one side of this debate, in terms of following these rules, following the procedure, would argue, look, if we missed it by a day, or if we did something that was not material to the public or really to the end result of the rule, we shouldn't be subject to scrutiny for a non-material breach of process. But again, if you fail to provide notice and comment on the front end, that is something the courts are going to review, right, I think, under APA. And so, we have this debate going back and forth about judicial review, and I think it challenges us all kind of going forward on how do we make everybody comfortable that there isn't an I gotcha here. There is an attempt to analyze and to know the rulemaking process so that everybody's playing from a level playing field, that the regulated community knows that this is the process, this is the rule of law that I'm operating under, and I can count on those steps being taken to protect my rights. And when those steps aren't taken, that creates a disharmony, and I think a sense that the government is run amok.
I ask Mr. Noe to make a comment? It looks like you're about to jump out of your seat.
Well, I just wanted to comment, Mr. Chairman, that I think there's a basic misunderstanding about this issue of delay, and I know Amit's concerned about that. I respect the idea of a concern about that, but it's very important to mention this because it's fundamental in the FDA good guidance practices, in the recommendations of ACUS and the ABA, that basically what they said is for significant guidance documents, the agency ought to ordinarily voluntarily comply with notice and comment, but unless they determine it's not feasible or appropriate. And when Congress passed FDAMA, that's right there in the statute, okay? So there's an out. This is very different than saying this is a legislative rule subject to APA notice and comment requirements and judicial review. It's very, very different because the agency can, on its discretion, determine, look, this one wasn't significant or it wasn't feasible to do it. What Congress said is if you don't provide pre-adoption notice and comment for the most consequential guidance and you go ahead and issue, you ought to still allow the public to comment on it even though it's out there already. And that is perfectly reasonable. That's what the Administrative Conference of the United States has said. That's what the ABA has said. That's what's in the FDA good guidance practices, and it works perfectly well. The agency has not crashed and burned. In fact, the regulated community, my understanding, I'm not an FDA expert, but they're pretty happy with how that works. And that to do it otherwise would be a major problem. So here you have an agency where human life is at stake in the decisions it makes, the guidance it provides, and this idea of having a presumption of public notice and an opportunity to say something about this before it goes final works perfectly well. And where they decide, look, it's not feasible, this is an emergency, or it's not appropriate, there's an out for that. And so I think that's the same kind of thing you could do if you elevate these good guidance practices to legislation for the agencies in general. To your point earlier, Senator Heitkamp, I think you could and should do it for the independent agencies too. Their guidance is no different in its impact. You have absolute authority to do that, of course. I frankly think the president has absolute authority to do it on his own. And I think there's
The
no
independent agencies don't think that.
They don't think that, but I think if you consulted legal scholars, they would line up and say that's correct. But the point is, it's you. You're a legislator. You have that authority. As far as judicial review goes, I don't think there's a whole lot for a court to review here other than if it's simply check the box. Again, we don't want to be embarrassed of our government. Do you have approval procedures for your most important guidance? Do you have standard elements in the guidance, and do you say it's non-binding? Do you provide access to the public by actually posting them on your website in the 21st century? Yes or no? If they didn't do that, you could provide limited judicial review to compel agency action unlawfully withheld or unreasonably delayed under the Administrative Procedure Act, Section 706(1). And all that anyone could do, if they're willing to spend the money, is get a court to say, yeah, you got to do what Congress told you to do. Nothing's going to crash and burn if you have that limited judicial review. I personally think you could do that.
So Paul makes a really good point. Congress has the authority and has mandated that certain agencies conduct guidance processes in a different way, in a much more robust way, as they did with the FDA. I think that is the proper way of congressional intervention in this area, is to go agency by agency where the problems exist, to the extent that they do exist, rather than a one-size-fits-all approach. I think this is a broader recommendation when it comes to regulatory reform legislation, generally speaking.
And we have established a one-size-fits-all by passing the Administrative Agencies Practice Act. So the question is, should that be expanded into other areas? Should we look at that and say there is a need for a broad-based rule of the road that could apply? I agree with you that there needs to be flexibility. I mean, the last thing you want is the IRS not to be issuing letter rulings.
Right.
And no one here wants that. And so I think you and I would agree it probably should be narrower than maybe what these guys would think. But I think at some point, having the certainty of knowing, I know what's going to come down because this is the process, and I look for it, and if it doesn't show up, I know there isn't new guidance out there that I need to worry about. And so I think there is some advantage that we could have to standardizing some kind of guidance principles, and making those, I think Paul's point about, what would that review look like? It's not substantive, it's really an objective review is what you're talking about, not a substantive review.
Yes, Senator,
right?
just the process. Did they do it? Did they do what Congress told them to do? That's simple.
So I mean, that offers an opportunity to give the certainty that you might need. Sorry.
And I don't want to. I do want to make clear that I'm not making any claims that significant guidance documents, economically, creation of these categories across agencies is going to lead to the same length of rulemakings as economically significant rules. That's not the case. It's not going to be as long as that. But even on the guidance end, delay is not an abstraction. It costs lives. The CDC opioid guidance is a great example. They wanted to issue it late last year. When they first came out with it, they got backlash from the pharmaceutical industry, and they had to delay the guidance until for several months. The CDC points out that 40 people across the country die every day from opioid addiction and overdose.
Mr. Cruz.
Just quickly, too, on the discussion about OIRA and the transparency that you brought up, it is the case that OIRA review, we always look at OIRA's reviews of regulations, but not the independent agencies, since those are left out. And in the past year, you have 13 rules that had a cost-benefit analysis done on them. But it turns out that OIRA does review some notices, and we can get to the bottom of what that data is actually telling us. And I'd mentioned that John Graham, who was the former head, said the OIRA website, this quote, is vague about what constitutes a notice. More clarity about what constitutes guidance notices worthy of review would be valuable. But I went back and looked, and it turns out there are a few dozen notices that OIRA reviews every year. The nature of what all of those are, we don't know yet. And even some of those are considered significant. So there is some activity at OIRA that would be enhanced by doing this, by enhancing those principles into legislation.